Welcome to The Explainer. Today, we're diving into the high-stakes world of patent infringement, a battle every single founder and inventor really needs to be ready for. So here's our game plan. We're going to walk through the entire conflict, from what patent infringement even is, to how a court figures it all out, what you can win, how you can defend yourself, and finally, the one thing that really decides who wins or loses. All right, let's jump right in. Imagine you're the patent holder. You've created something amazing, you've protected it, but now you see someone else on your turf. So picture this. You've poured your time, your money, your whole life into a product. You did the right thing, you got a patent, and then you see it. A competitor is making, using, or selling your exact invention without your permission. That right there is the first shot fired in a patent war. Legally, we call this patent infringement. It's a direct violation of your rights. The best way to think about it is like this. Your patent is the deed to a piece of land. Infringement is someone else building a house right in the middle of your property without asking. They are trespassing. Simple as that. And the law is super specific about what counts as trespassing here. It's not just about who's manufacturing it. Just using it or selling it or even importing it into the country, all of that counts. And here's a big one for founders. If you actively encourage someone else to infringe, you could be on the hook too. Okay, so now we move to the battlefield, the courtroom. Let's look at how a judge actually decides if infringement happened. It's, not as simple as just holding two products up and saying, yep, they look the same. A court uses a really strict two-step process. First, the judge carefully reads the language of the patent's claims. This is like looking at the exact property lines on that land deed we talked about. They need to know precisely what you own. Then, and only then, do they compare the other guy's product to those claims to see if it's on your property. Now, this is where it gets really interesting, right? Because smart infringers, they almost never make a perfect one-to-one copy. They'll try to change a little something here or swap out a material there. So what happens then? Well, this gives you two main ways to win in court. The first is called literal infringement. That's the easy one. It's an exact match, element for element. But the second one, this is a really powerful tool. It's called the doctrine of equivalence. It basically means that even if a competitor makes a small change, if that new part does the same job in the same way to get the same result, it's still infringement. It's the law's way of saying, nice try, but that's still a copy. Infringement isn't just a single thing. It actually comes in a few different flavors. And understanding these is like knowing all the different weapons you might face and the ones you can use yourself. So let's break these down. Direct infringement is obvious. Someone is making or selling your invention. Indirect is when somebody helps or encourages someone else to do it. Then you've got contributory infringement. That's when someone sells a key part that has no other real use except to be part of the infringing product. And then there's the big one, willful infringement. This is when they knew about your patent and just decided to copy it anyway. That can lead to way bigger penalties, sometimes triple the damages. Okay, so let's say you've gone to court, you've fought the battle, and you won. What do you actually get? Well, the spoils of this war can be huge, and they can completely change the future of your company. A win gets you two incredibly powerful things. First, an injunction. That's a court order that forces the other company to stop everything, immediately. It takes their product right off the market. And second, of course, are damages. Money to pay you back for all the harm they caused your business. But hey, this is a two-way street. What happens if you're the one being accused? Let's flip the whole thing around and look at the strategy from the defense's point of view. A big, scary letter from a lawyer lands on your desk. Maybe it's even a full-blown lawsuit. It's a moment that would make any founder's heart stop. But listen, an accusation is not a guilty verdict. You have some really powerful ways to fight back. This is far from over. Your best counterattack, your number one move, often isn't just arguing that your product is different. The absolute strongest defense is to prove that the patent you're being accused of infringing is actually invalid and shouldn't have been granted in the first place. And here's how that works. Your legal team goes on a hunt. They conduct what's called a validity search to find something called prior art. Prior art is basically any evidence out there in the world. An old scientific paper, a product someone sold years ago, even a YouTube video that proves the so-called new invention was already known to the public. If you can show the invention wasn't actually new, the patent gets invalidated. And just like that, the lawsuit disappears. So we've looked at playing offense, we've looked at playing defense, but in this whole complicated, expensive battle, winning for either side, it all comes down to one single critical thing. And this right here is the key to everything. It all comes down to the patent's claims. Those specific words that are used to define the boundaries of your invention, that's what the entire fight is about. A badly written claim can make an amazing invention totally worthless, but a well-crafted claim, that can be an unbreakable shield. So, in the end, whether you're protecting your own patent or trying to launch a new product without getting sued, your success depends entirely on the strength and the clarity of those words on the page, which leaves every single innovator with one really important question to think about. Is your claim truly strong enough to survive the fight,